Hi, my name's NicoleThompson and I run NMTHR Services Limited based up near Consett in County Durham. I'm pulling together this video to try and help with those small businesses which are struggling to come to terms with GDPR, and I'm hoping that it will give you a good starting point. I'm going to run through a presentation with you and just to get you started and look at ways in which you need to be compliant, the new 8 rights that are afforded to individuals under the new regulations, and the lawful bases under which you can process personal data. So I am running some workshops up in Consett, but I do realise that not everyone can get to those. They are very practical workshops with lots of toolkits and handouts, but I do understand, as I say, that not everyone can get to those. So I'm hoping that this presentation will go some way to help people, and I will link to certain documents that you can use. I'm just going to share with you the presentation screen and then we can get started. Okay, so we're going to have a look at a number of things within this presentation. What is GDPR? What data is covered? The new rights that are afforded to individual under GDPR? Who's responsible within your business for the protection of data? Ways in which you can become compliant and where to start in the process. We're going to touch on data belonging to children and vulnerable adults. We are also going to look at data breaches, what is a data breach and how you handle that, the retention of data and training and development of staff within your business. It may not cover everything that everyone needs to know. You've all got different businesses in various sectors, but I'm trying to give everyone a good start to getting a handle on this. And we can tackle questions webinar if we need to. So what is GDPR? Well, basically, as a small business, you will be familiar with the Data Protection Act, and that's an act that's currently there under UK law to protect people's personal data. So you already have obligations under that act when you are handling sensitive and personal data, but the rules on that are changing under what is now known as the General Data Protection Regulations, or GDPR, which are coming into force on the 25th of May. So the GDPR does impose greater accountability on businesses who are handling personal data, and it does give more rights and controls for individuals around the personal data that you hold on them. If you look at this simply, you are an individual whose personal data is more than likely being processed and handled by someone or a business. And it's simply thinking about what is it that you would want to know if someone's storing and handling your personal data, and how you could get access to that and applying those principles to your business. There are increased fines and penalties under GDPR, and it does give the Information Commissioner's Office, or the ICO as it's otherwise known, the right to impose those increased fines and penalties. However, looking at their website, they're saying that businesses should not just focus on this, and it's not all going to be around the imposition of higher fines or further fines or more fines. It's going to be more around them coming into a small business who they realise may be struggling with this whole process and giving them the support and help that they need in the first instance. Yes, there may be businesses out there. We've all heard of the recent incidences with Facebook, but who may have to be more accountable. But it's more about, in the first stages, giving businesses the support that they need to get started. So what data is covered by GDPR? So basically, personal data is any data that relates to a natural person, and that includes identifiers, which are things like the name, address, the NI number, it could be a PPS number, which is a benefits number, and their address. Any phone number or photo that can identify an individual is also known as personal data. Then there's a category known as sensitive personal data, and this can be medical conditions, it can be financial information around incomes, or it could be around their visa number, bank details, or it could relate to their health, their racial origins, political opinions, their sex life, commission of an offence, or biometric and genetic data. Anything that's classed as sensitive personal data, additional care is required. So there's some new rights that are being afforded to individuals under the GDPR. And the first one of these is the right to be informed. So the individual will have the right to be informed about the types of personal data that you hold for them, how you obtain that personal data, what you do with it and how it's stored, and whether it's passed on to any third party. They also have the right to access their data. This is known as a subject access request. So they can come along to you at any time, that could be a client or an employee in your business, and ask to see the data that you hold for them. Now, under the Data Protection Act, you had 45 days to respond to that data request, and you could charge £10 for them to access their data to cover admin costs. Now you have to provide that data free of charge, although that does come with some what ifs, and you have 30 days to comply with the request. Now, as I say, you are supposed to provide that data free of charge. However, if you feel that it is an excessive request that will take an inordinate amount of time for you to collect and supply that information to them, then you could charge an admin fee, but you would have to be very clear on why you're doing that. You can also ask for an extension to time if you feel that it is excessive and going to take you a long period of time. Or you can ask them to shorten the amount of data that they're asking to see and give you scope for providing the data within the 30 days allotted time period. They do have the right to ask for data to be rectified if they feel that you've made a mistake, and they also have the right to restrict processing. They also have the right to ask you to port their data across to somebody else. So it could be someone else that they want to move to, and you would have to comply with that request. You can't charge them for your time in doing that, but you would have to ensure, for example, that you've got the same operating platforms or software that would enable you to do that with the other person that they want you to transfer the data to. They also have the right to object to you processing their data. Now, points D and F on that list also have come with caveats. So if you had a legitimate interest or a lawful basis that overrides their request to restrict processing or object to you processing, then you have the right to continue processing. And you would have to be very clear on what that lawful basis is. We're going to come on to the 6 lawful basis shortly, but you don't just have to comply with those requests if you feel that there's another reason that would override that request that is legitimate and lawful. They also have the right to ask you to be forgotten, so for their data to be erased and for them to be taken off your list. Again, you might have reasons why you have to hang on to data, and it will come on to data retention later within this video. But again, you would have to be very clear on why that is. But they do have the right to be forgotten. And that could mean that you just stop processing the data, but you still hold the data. They also have the right to ask any questions that they feel fit or as required about the personal data that you're holding, storing and processing for them. There are new rights as well relating to automated decision making, including profiling. We're not going to go through them in this video, but I do have a lot of information around that if anybody needs extra help on automated decision making or profiling. So I do have a checklist that you can use under the right to be informed. If you would like a copy, you can just message me. I'm going to give you my Facebook page a bit later, and I will send you a copy of the checklist. Who's responsible for data protection within your business? Now, there's 3 categories here. There's a data controller, there's a data processor, and there's a data protection officer. Generally, the data controller is either the business owner or the business themselves. And basically, the data controller is the person or business that choose the data that's required, the personal data, and decide on the usage of that data. So they are ultimately responsible for the security of the personal data. There's also someone known as a data processor. So this could be someone who manipulates or uses and processes the data on behalf of the data controller. So it could be business employees, or it could be an external payroll department or accountants, or another third party that you pass that data onto for processing. There's also a data protection officer. Now, the GDPR does make it a requirement that organisations appoint a data protection officer in some circumstances. We're not going to go into all of the circumstances in this video. However, for most small businesses, it will not be a legal requirement for you to have a DPO, but it would be beneficial for your business if you appoint someone that's responsible for your data obligations, and we'll look at that a little bit later on as well. In terms of becoming compliant, under GDPR, there is a requirement for the business to prove a legal basis for which they are collecting personal data. That could be employee or client's information. So for a beauty salon, it could be that asking about allergies and skin conditions is for health and safety purposes. Or it could be that for you to manage that person's personal data, and for you to need to collect that personal data, you have a legal basis for doing that, and we will touch on those shortly. You cannot just state any longer that it's for marketing purposes. That will strictly not be allowed under GDPR. But I do have a checklist as well that you can use and look at to go through to see which of the lawful basis you would need for processing data within your business. So what are the 6 lawful bases for processing data? No single basis is better or more important than any one of the others, but at least one of these must apply whenever you process personal data within your business. Consent is where the individual has given clear consent for you to process their personal data for a specific purpose. And that's going to be the most common lawful basis for processing data. You must be very clear on the specific purpose, and they must know exactly what you're doing with the data before they give you consent. However, I have heard people saying that if they don't have consent, they can't process personal data. That's not strictly true. If you have one of these other 5 lawful bases for processing data, then you can still process personal data. But you have to be very clear on what your lawful basis is. And once you start processing the personal data under one of these reasons, you can't suddenly swap to another reason. So you have to be very clear from the beginning. You could be processing under what's known as a contractual basis, and the processing is necessary for a contract that you have with the individual, or because they have asked you to take specific steps before entering into the contract, and that the only way that you can do that is to collect some personal data from them. It could be that you have a legal obligation, so the processing is necessary for you to comply with the law. So that's not including contractual obligations. So for example, if you are asking employees to give you some form of ID, which would be classed as personal data, to prove their right to work in the UK, then that would be a legal obligation, because the UK Border Agency within the UK asks you to do that before you take anybody on board as an employee of your business. Data, and that the vital interest is necessary to protect someone's life. Now, I have said we'll discuss this later, but basically That would only be if anyone's got any specific questions around vital interests. But vital interest, an example could be that a medical centre needs to provide a hospital with some personal data around someone's medical condition or their health that would save their life. Or a hospital has to pass it on to somebody else who's going to maybe operate on an individual to help them save that person's life. It could be that there's a public task involved in processing the personal data and that you need that data to perform a task in the public interest or for your official functions. And the task or function has a clear basis in law. Or it could be that you have a legitimate interest. So the processing is necessary for your legitimate interest or the legitimate interest of a third party, unless there is a good reason to protect the individual's personal data, which overrides those legitimate interests. So if you were going to put somebody in danger or put them in harm's way by processing their personal data under legitimate interest basis, then you couldn't just go ahead. But again, I have a checklist which goes into this in far more detail, which you can have a copy of if you send me a message. So where do you start? Well, the first thing is to conduct a data audit. So look at what data you hold and why, how it comes into your business. Does it come directly from the individual or does it come from a third party? And how do you process and store it and where is the data sent? So this is also known as data mapping. If you do have managers or staff within your business, ask them what personal data they hold for clients. So basically ensure that absolutely everyone in your business knows what they're doing with personal data, why it comes in, what you do with it, what's your lawful basis for having it in the first place, how long you store it, etc., etc. And we'll come on to that in a little bit. So you also need to look at in what activities do you process personal data. So if you have particular activities within your business that require you to collect and store and hold personal data, look at what they are and start to list them. I would also conduct a risk assessment. So assess the potential risks to the data that you hold. So for example, what data that you hold and process could be at greatest risk if an unauthorized person gained access to it. And then focus on that in the first place. So this could be a credit card detail or sensitive medical details. And I would prioritize the riskiest ones now and plan how you will protect that data and then look at the less riskier ones over the following weeks. I would assess your data handling activities. So look at the internal audit that we talked about in the previous slide and start to log everything that you do. Ensure that your systems store personal data properly and securely, and delete any unnecessary data to minimize that risk. You need to do that securely. There are businesses out there that will advise you on how to delete personal data securely. But basically, if you've got data that you no longer need, then just get rid of it. If you offer services to children, you need to ensure that you use clear and plain English language that they will understand, and we'll come on to that in the next few slides. And familiarise yourself with GDPR, including the 8 rights that individuals have, and ensure that your procedures and policies can deliver those rights. Inform and train your employees of GDPR and how this will affect the running of your business. And we're going to come on to training employees shortly. But more than anything now, data should be a high priority for your business, and keeping up to date with developments will be crucial. I would add that there are things still changing within GDPR, and on the Information Commissioner's website, there are things that are still evolving and developing. So it's important that you follow any blogs or any updates on what has changed within the regulations, because they do have up until the 25th of May to decide exactly what is happening under the new regs. So document your processing activities. So the GDPR is quite explicit about the requirements about documenting your data processing activities. You must maintain records on several things, such as processing purposes, data sharing, and retention. And you may be required to make the records available to the ICO on request. Controllers and processors both have documentation obligations. It doesn't just fall down to one of those parties. Each person or each business has specific documentation obligations. For small and medium-sized organisations, if you're under 250 employees, you will be pleased to know that the documentation requirements are limited to certain types of processing activities, and you will not be required to document the full range of activities as a larger business would be required. But records must be kept in writing, so most businesses will benefit from maintaining their records electronically and having them secure and safe. And they concern that everyone who needs to know within their business does know about the records that are being kept and why. Any record that you hold on your processing activities and on personal data in general must be kept up to date and must reflect your current processing activities. So to help you with this, there's two types of spreadsheet that are available. They're available on this ICO website, but I've got links to them. If anyone needs to have copies, just please get in touch, and that will just save you going onto the ICO website and looking for them. So there's a specific spreadsheet for a data controller that basically has a number of columns on it, and it will just ask you to start recording certain types of data that you hold and process. But just going through that activity in itself really helps to tidy your mind and get you to think about, well, why am I holding the data in the first place? Why have I asked for it? What am I doing with it? And do I still need to keep it? And have I got consent? And am I ensuring that I follow the legal rights that people have in terms of the data that I'm processing for them? So it's a one-stop shop, if you like, of all your activities on one spreadsheet. If you're not certain how to operate a spreadsheet, then I can do a tutorial on that, and I can help you to link your documents into that spreadsheet. But I need to know if people need help on that. So there's a spreadsheet for a data controller and there's one for a data processor, but they are available on the ICO website. If you're not already registered on the ICO website, we'll come on to that shortly, you can go on and try the self-assessment toolkit, which does also help you to think about why you are collecting and holding and storing data and what you're doing with it. So you do need to register with the Information Commissioner's Office. There are a couple of exceptions, but generally most businesses will need to register. And that is a requirement that's imposed on a business by the ICO. So there's currently more than 490,000 organisations registered. That number's probably gone up since I last looked because of all this activity around GDPR. And you need to be aware that clients and employees can go on to the ICO website and just check if your business is registered. And they could raise a complaint if they feel that you are processing personal data and you're not registered. Currently, the fee to register is £35, and that is going up shortly to £40. But there are going to be a number of tiered registration fees, which I do talk about and give access to on my Facebook page. So if you want to find out more information or look at any of the information blogs that I'm putting out, then please look at my Facebook page. So where do you start? Well, a good place to start would be to have clearly written and communicated policies in place. And the ICO and the FSB recommend that you consider having the following. So a general data protection policy. If you currently have a data protection policy, it will need to be far more detailed than it currently is, and it will have to be much more explicit on what you're doing with the data. You can't just have a catch-all policy. For any of my current clients who are watching this video, if you do have a data protection policy that I've created for you, I will be updating that, so have no fear, and I will be sending you an updated policy. However, I am hanging on as long as I can because things are changing about the wording in those policies. So please bear with me. They also suggest that you have a subject access request policy. Now, personally, I would only do that if you feel that you are going to get a lot of requests for people to start accessing their personal data. If you do start to get requests and you don't have that policy, then I can help you with it. However, this isn't a sales pitch. It's more about sharing information with you and giving you an overview of what you will be required to have in place. They also suggest that you have a data retention policy. Now, if you are processing lots of different types of data and there are legal obligations imposed on you to store certain types of data for certain periods of time, then it would be a good idea to have a data retention policy, because it's in creating that document, it does make you think, but it also is a document that you can put in front of any clients and make them aware, or it could be a document that you put in front of your employees and staff to make certain that they are aware of how long they should be keeping and holding data for. When I talk about legal obligations being placed on you to hold and store certain types of data, it could be that if you're processing payroll information, for example, then the HMRC would require you to hang on to those sorts of data for certain periods of time. It could be that you've had a dispute with a client or an employee, and it would be wise to hold on to any information that's relating to that dispute, which involves personal data, for a certain period of time. Or if you've had to dismiss an employee, then hang on to certain data around that type of situation. They also advise that you have a data breach policy. Again, it might be a good idea to consider that at some point in the future. Again, to just raise awareness levels within your business for anyone who's storing and handling data on your behalf, and what they should be doing and how they should escalate it if they feel that there's a breach of data or a suspected breach of data. And it also gives confidence to your clients if they know that you've got a breach policy and how they can raise a complaint. Now, the privacy policy and the privacy notice for clients and suppliers, these are really useful documents when I've had a look at them. And the privacy policy would really help you in terms of your consent policies. And the privacy notice for clients and suppliers is something that you can make very open to them, so they know exactly what's going on with their personal data. And you can link it to a terms of website use policy if you have a website, and you can put everything there on your website that's very clear and transparent. They also suggest that you have a CCTV policy. Obviously, you wouldn't need one of these if you don't operate CCTV on your premises. You might already have a CCTV policy. I would just make certain that it's up to date and compliant with GDPR if you do have. Otherwise, I can supply you with samples of a CCTV policy that would be useful. Also make certain that you have very clear signs around the building and in the workplace that do say that you're operating CCTV and for what purpose any footage may be used. However, I would look at starting small, and I would do all the logging of your data processing first and then decide if you need any of the above. And I can help you, and I will give you sound advice on an essential need basis only. As I said before, this isn't a sales pitch. I'm more interested in sharing as much information as I can with small businesses that may be struggling with this. If you do have any data belonging to children and vulnerable adults, you need to be aware that there are additional protections for them under GDPR. I'm sure if you are dealing with children and vulnerable adults, you do already have safeguarding measures in place, but you do need to consider the following. So a child is anyone under the age of 16. This may be reduced in some countries, and I know that Ireland, for example, are looking to say a child is 13 years of age and under, and that consent of the child and parent or guardian must be collected before collecting any personal data from them. So you need to ensure that anyone under the age of 16 has got parental or guardian consent before you collect and store and hold and process their personal data. So sensitive personal data such as health and medical conditions, there's additional restrictions on these in the case of a child. So for example, if you're a salon and you're asking a child for sensitive health or medical information to be able to give them treatments, then you should avoid offering such services where you can. If you can't do that, then I would take your own legal advice on that and ensure that you're fully compliant and that you're not placing your business at risk through any of the services that you're offering. If you offer an information society or an online service to children, you may need to obtain consent from a parent or guardian to process a child's data. So I would suggest that you look into those regulations much more closely and ensure, as I said before, that you're not putting your business at risk. In terms of data breaches, the GDPR introduces a duty on all organisations to report certain types of personal data breach to the ICO. You must do this within 72 hours of becoming aware of the breach where feasible. Now, previously under the Data Protection Act, you had a longer time frame in which to do that, but also you could supply that, you didn't have to supply a notification of a data breach, and you were not, it wasn't that you had to do it, it was that the ICO would like you to report a data breach, but now you must report it within 72 hours, depending on the type of data breach that it is. So if the breach is likely to result in a high risk of adversely affecting the individual's rights, then and their freedoms, then you must also inform the individual without any undue delay. You should ensure that you do have procedures in place, which goes back to that data breach policy, to handle a data breach, and that staff know to report any data breach or suspected data breach to management. Importantly, you must also keep a record of any data breaches, regardless of whether you are required to notify them or not. So, what is a personal data breach? So it basically means it's a breach of security that would lead to the accidental or unlawful destruction, loss, alteration, unauthorized disclosure of or access to personal data. So this includes breaches that are result of both accidental and deliberate causes, but it importantly means that a breach is more than just about losing personal data. So examples will include access by an unauthorized third party. So if you send data out to, personal data out to a third party, and you haven't had permission from your client or employee to do that, then that could be unauthorized access by a third party. Deliberate or accidental action or inaction by a controller or processor. So it could be that as a data controller, you've deliberately done something and that results in a data breach. Or it could be that a processor, someone who's processing the information on your behalf, has done a deliberate action. Or it could be through their inactions that they've caused a data breach. So not ensuring that there's security on the personal data that they hold, for example. Could be that personal data has been sent to the incorrect recipient. We're going to talk about that shortly within staff training. And it could be that computing devices containing personal data being lost or stolen. It's really, really important that you don't have data on computers that isn't encrypted, that you don't have passwords on, that you don't have staff walking around with personal data belonging to your business or your business clients or employees on their personal phones. If they have it on a securely locked and securely passworded business phone, that's different. But a number of small businesses have said to me, my staff access emails from home on their personal phones or even on their personal laptops. That is a definite no-no, and you need to do everything you can to ensure that that doesn't continue to happen. Another example of a data breach could be the alteration of personal data without permission. So it could be that someone that you're processing data for, you've gone into their data and you've made a change and they haven't asked you to do that, or they haven't given you permission to do that. Or you could lose the availability of personal data. So it could be that you or someone else in your business or a data processor that you've engaged to manipulate or process that data has simply pressed the delete button in error and they've lost your data. So you need to think about your backup systems within your business and how you could retrieve any personal data that has been inadvertently lost. Again, there could be a potential fine, but it's more about your reputational damage, loss of brand, confidence, and potential loss of business and income. Particularly if you're small in business, it's going to impact any business, but small business, it could have a massive impact straight away. So retention of data. The best practice advice is that you need to review the length of time that you keep personal data, consider the purposes that you hold the information for in deciding whether and for how long you retain the data, and securely delete information that's no longer needed. Don't clog up your business processes if you've got data there that's no longer required, unless you need to hold on to it for a legal purpose. So you have a requirement under some sort of legal framework or statute whereby you need to keep that data and retain that information for a certain period of time. And then ensure that you update, archive, or securely delete information if it does go out of date. So in terms of the GDPR and Data Protection Act, there's no specific minimum or maximum periods for retaining personal data. Instead, it states that personal data processed for any purpose or purposes shall not be kept for longer than is necessary for that purpose or purposes. So ensuring that personal data, again, is disposed of when no longer needed will reduce the risk that it will become inaccurate, out of date, or irrelevant. I would advocate that you train staff and raise awareness around best practice as soon as possible. You've got until the 25th of May to ensure that everybody in your business knows what's happening in terms of GDPR and whatever processes you're putting in place to ensure that you become compliant. Ignorance is not going to be a defence. It's got to be an ongoing process in terms of staff training and development. So every time you change something or there's a change under GDPR, you need to ensure that your policies are updated, your processes, and that your staff are trained and fully aware. I would make certain that any staff training you deliver, the member of staff signs for that training, and you keep that on their personnel file to prove that they have received some sort of training from you. It could be that you appoint a GDPR champion within your business and they can educate the rest of the team and work on your policies and procedures. So this could be a receptionist or someone's time that could be used in a better way. And they would have the aptitude and desire to want to take this on. So if you have someone who absolutely thrives on processes and systems within your business and is a bit of a nerd, if you like, around ensuring that they tick every box and dot all the I's, then I would make certain that that's your person who becomes your GDPR champion, because they will probably embrace this and do the best job ever for you. Again, in terms of training all your workforce, human error accounts for the majority of data breaches. Mishandling, mislaying, or wrongly storing paper files can cause huge problems for you. and for the customer and the employee. So simply losing a laptop or a data stick with unencrypted data files, or sending an email to the wrong person, or giving out personal data to the wrong person or a relative of a client or employee. So if you do have a subject access request, make certain that you or your member of staff who's handling that does get ID from the person who's asking for data. There will be some people who you automatically have to give the right to access personal data, so it could be a law enforcement body, for example, but even in that case, I would check the ID of the person who's asking for the personal data. It could be that a member of staff inadvertently sends an email to somebody incorrectly with somebody else's personal data on. So you need to think about ways that you can avoid that, checking processes, and that they flag that straight away if that's been the case. But again, no personal data stored on any personal devices. That is extremely risky. You have no control on that data whatsoever, and you could be in real hot water. Particularly, you need to check with your insurance companies if you're covered for that. I would very much doubt that you are, and you need to have some sort of home working policy if you've got people working from home that are handling data, and ensure that their systems are secure. But the best advice is just simply have all personal data stored on company-owned devices. Review together with your staff and your management team how you store data. Is it pen and paper records? Is it in diaries? So how can you ensure the security of pen and paper records and diaries? Have a clean desk policy. Make certain that, for example, if someone coming into reception can't see what's in diaries, can't see what's on paper records. If you do have to have paper records, make certain that they're in stored lockable cabinets, and that only certain people have access to the keys, and that you have a key control system. But password protect on absolutely everything. Ensure that your staff don't share passwords, that they update them regularly. If they go away from their laptop, that they lock the computer so that someone else coming past the laptop can't see the screen and see any personal data that's stored on there. It's really important. So in summary, assure that all data security, handling and processing arrangements are set out in policies and procedures where possible, and are regularly reviewed and updated. Prepare a plan or policy for handling subject access requests or requests for additional information under GDPR, and communicate your plan and policy to your staff. So you do have a certain time frame in which to comply with subject access requests. It's 30 days under GDPR. And you're not allowed to charge anyone, whether it's a member of the public or an employee, to have that personal data belonging to them, unless you feel that the information that you're having to supply is excessive and it's going to take you an inordinate amount of time to supply. Then you can look at charging an admin fee, but you would have to be very clear up front that that would be the case and why you would be imposing a fee. You can also ask for an extension in time, and again, you would have to be very, very clear why that would be. It could be that you've got someone on holiday who would be able to supply that information, or again, it could be that it's an extremely excessive request. If someone is asking for information that you've previously supplied, then again, you could look at charging a fee for doing that. But general rule of thumb is no fee and 30 days to comply with the request. Prepare a document which outlines clearly how personal data is to be handled and is secured, and what employees should do if there's a breach. And review and amend your privacy policies for your customers, suppliers, and third-party data controllers. Evaluate and review your data consent processes in preparation for GDPR. So these have to be very clear. Consent must be freely given, specific, informed, and unambiguous. Gone are the days of relying on assumptions or pre-ticked boxes or silence. They can't be used as forms of consent. and people must make a positive opt-in. You must provide a simple way also for people to be able to withdraw consent. You must not only get consent to send commercial emails, but you must also keep records of consent. If you buy data or you buy a client database from a third party, you must make sure that you obtain the necessary documentation to show compliance. So I cannot stress enough that if you are using third parties to either get data from or to process data on your behalf, you check what they have put in place to ensure they are compliant under GDPR, so that you do not have any problems coming back to your business. If you do have any questions, I've given you a link to my Facebook page, and please note any questions on there. I might not be able to answer individual questions. It might be that I just have a look over a period of time and see what seems to be a general theme, and then I post some generic responses. It's all going to be down to how much response I get to this video and how many questions I have coming through. Again, if anyone wants to get in contact with me, please inbox me, and I will try and help in any way that I can. But again, that depends on the volume that comes through. And if I need to do further tutorials via video, then I will do, to try and break some of these areas down further for you. But I hope it has been of some use. If you feel it has, then please give me the thumbs up on the link. Happy for you to share the link, and again, come back to me if you need more. Thank you very much.